All right. So we know that last couple weeks we spent on the Sixth Amendment on a couple of specific rights, the right to counsel, the right to a speedy trial, and some of those related ones. And we may go back and hit some more of those based on what you guys are interested in, kind of where we're at in the semester, as we finish up on the 8th Amendment this week and on the 13th, 14th, and 15th Amendment in the coming weeks. So for today, we have Coker. So the reason that I don't do an introductory PowerPoint on the 8th Amendment, all right, for those of, I should have just waited literally 2 minutes. That was on me. All right, as more of you joining us, just a quick recap. I won't rehash everything I just said, but we are moving forward with the 8th Amendment, and one of the reasons that I don't give an introductory lecture on the 8th Amendment like I do in the others is because the 8th Amendment outside of capital punishment doesn't have a ton of litigation. Right now, we're seeing an increase of litigation because of the interest, an increased interest specifically in bail reform, because the 8th Amendment, in addition to barring cruel and unusual punishment, also bars excessive bail. Now, one important thing there is to note about that, especially as we kind of discuss, or as bail reform is a constant topic of conversation in recent criminal legal discussion, is that you have no constitutional requirement to bail. You do not have to get it per the Constitution. It is not a right. What the Constitution instead prohibits is excessive bail. So what it's kind of intrinsically recognizes is that bail should be apportioned and should be in kind of correspondence or in proportionate amount to what an individual can provide, because what I, Professor MK, consider to be excessive is probably a lot higher than what Adrian or Abdullah or any of you in the undergraduate program might consider to be excessive, and then even more, or perhaps, I don't actually know who would be considered more broke if when you're in undergrad versus graduate school. I don't know. But to an extent that there is a difference, let's just say that there, or we'll just assume that there is one, but to any difference that there is, still, even more, that would change the conversation. So what it means is that essentially all the conversations that are about bail reform are like, hey, we really have to pay attention to this because historically we have not. Pretty much we have what are called the going rates in bail, which is in St. Louis, to give an example, if a individual was arrested and placed in custody for felon and possession of a firearm. Does anybody want to guess what the standard bail was for that offense, singular offense, one Class D felony? Felon in possession of a firearm, what the going rate was.
In what year did you say? When you were there?
Yeah, when I was there.
10 grand.
30 grand cash only. That was the going rate. And obviously that was for any person, whether they had a public defender or whether they were hiring Scott Rosenblum, who is Nellie's attorney, for comparison. That's a St. Louis attorney, and Nellie is from St. Louis, if anyone didn't know that. So he has some charges that he had faced some previous times in his life and when he visits every now and then, and he keeps Scott Rosenblum on retainer for that reason. So big difference between what you're able to make as far as bail is concerned. But for a really long time, that's what we did, is have a going rate for pretty much the offense. It didn't necessarily even had to be the offender. And what the bail reform movements are saying is like, actually, the Constitution necessarily asks you to look at the offender and their person and whether or not it's excessive for them. So, for instance, I got a Google alert that Trump was just ordered to pay $4.64 million in bond before Monday. So obviously, categorization of, is that excessive? For all of us here in this room, absolutely, that's an excessive amount. Is that an excessive amount for someone like Donald Trump, who has access to billions of dollars at a given time? The court's probably going to say no, because again, has access to that much money. Same thing when Harvey Weinstein was on bail or bond, and he cashed that out immediately, and he was on like millions of dollars of bond. For most people, that is definitely going to be excessive. So we're seeing some litigation occur in the area of bail and bail reform. But it's still not a ton, and I pretty much just summarized it all for you in I've been talking for about 5 minutes. So that's kind of we're seeing the movement. A lot of it is the pushback on what to do because the community obviously has safety concerns. 1.7 million was Harvey Weinstein's, or sorry, 175.
Trump just announced, like, I just got a notification like 10 minutes ago that he is going to pay 175 million in bonds and shit. I don't know.
He owes 400 and something, I believe it's so. It got reduced and delayed. You guys are keeping much more up with this case than I am, and I honestly I should be, but I can't watch that man anymore. Anyway, so back to bail and bond. We that pretty much summarized that discussion for you. That's happened. The biggest pushback is, of course, political and community safety, being what do we do? Because we have to recognize that there is an increase or there's been some kind of shift in offenses while on bond. So we have to kind of look at what that means and what does that mean for community expectations and things of that nature. The rest of litigation around cruel and unusual punishment that is not capital punishment tends to have to do with prison conditions. And there have been I would say not an insubstantial amount, but it's there. Amount of litigation on kind of essentially what prisoners are entitled to and not entitled to while in custody. And a lot of the litigation also tends to discuss especially what they're entitled to with respect to religious practices and whether or not it's cruel and unusual punishment or a violation of the First Amendment to deny them certain things like a kosher diet. Is that cruel and unusual punishment to force someone who is Muslim to eat certain foods that they would consider to be problematic, or for the same thing for a Jewish prisoner to eat things that are not kosher? And does it implicate both the First Amendment and the Eighth Amendment? There's also concerns about, youth in prison. So the general conditions and qualities are sometimes things that are litigated, but by and large, the most litigation that happens in the Eighth Amendment is about capital punishment. So that's why we read capital punishment cases only. It's also having taught many students several times, I know that you don't want to read bail reform cases because they're highly technical. You don't want to read any of the other ones. You want to read and listen about death and grisly murders. So with that said, let's dive into the cases for this week. So someone who wants to tell me who did not take my death penalty class last semester. So graduate students, that means you. Who wants to tell me the legally relevant facts of Coker? And I will say that I do pick these cases on purpose, and I like picking these cases because they make students the most uncomfortable. So someone want to tell me the legally relevant facts of Coker? First, not graduate student, and then if no one wants to talk and a graduate student wants to jump in, they can. Adrian, go ahead.
So basically, Coker, he was serving a number of sentences for murder, rape, kidnapping, assault, and he escaped from prison. He broke into like a Georgia couple's house.
Mhm.
He raped the woman and stole the family's car, and then the woman, she was like released shortly thereafter without further injuries. But then they caught Coker, and basically the court for Georgia, they sentenced Coker to death on the rape charge.
Mm-hmm. So Gracie asked this in the chat, and I actually don't know. I don't know if it's in the record. Because I don't remember it as a fact. Does anyone know how he escaped prison? No, it's not in the record. I didn't think it was because I've never known this information, and I feel like I would have. I don't. Here's the thing. I'm going to say it's too hard, but if we look at the point in time in which Coker would have escaped, prisons are certainly not what they used to be, especially if we consider Ted Bundy escaped from custody like 3 or 4 times. He was a very slippery little trickster. So didn't used to be quite as difficult to break out of custody. now I think if anyone has been through a jail or has like, I don't want to talk about potentially problematic portrayed. Joshua says portrayed greatly by Zac Efron. I actually didn't watch that version because I watched the real version, documentary version first, the tapes, and it freaked me out so bad. It was actually a time in which Dr. McCuddy and I were not residing in the same house, and I made him come over at 4 a.m. because I could not go to sleep after watching the real version. It freaked me out so bad. Anyway, side note. So, didn't used to be quite so difficult to accomplish those things. And of course, we still see that happens actually every now and then, occasionally. So I think the best people to ask would be maybe how, from my understanding, it's usually a situation in which they were given some level of privileges or were at some point alone, which usually is, again, part of privileges that you get while in custody, because that's not a common thing, is that you'd be residing in time alone, or they're on some kind of movement. Like I know one of the last stories I read about someone who broke out in like New York was they had like a laundry shift, and so they were one of the cars that drove, and they got out on that route and broke or left the car crashed somewhere. So things like that. It's not always the Shawshank Redemption, like tunneling under or out kind of situation. That's not really what we do, or what my understanding is how you would break out now. But great question, Gracie. No idea. So yes, Coker is in custody. By the way, what is Coker in custody for? What was he in prison for?
Murder, rape, assault.
So he was actually already in prison for murder, a kidnapping, and a rape. So a crime pretty much exactly this, except he actually killed his victim the first time, and the court or the jury, for whatever reason, did not give him the death penalty. He didn't get it, even though he was serving a murder sentence. So he gets out and he commits this new offense, this rape. And so his case goes forward. And essentially, what is the legal issue that his defense team and Coker are taking up in this case?
Does the mandatory death sentence for a rape conviction truly violate the Eighth Amendment of the petitioner? Would be kind of the issue. It would be.
Lorena says, okay, go ahead, Joshua. I saw your hand raised.
I mean, better have it.
Go ahead. Do you have another way?
I mean, it's gonna be the same exact way, just worded a little bit differently. So, I mean, it's really
Give it a shot.
Does the I can't even think on. Does the rape charge is it unconstitutional to charge or to impose the death penalty? I can't even think of it anymore.
No, you had it.
Unconstitutional
to impose
is it
the death
unconstitutional the Eighth
penalty.
Amendment to impose the death penalty on a rape charge?
Mm-hmm.
Or after multiple, like depending on the extremity of the rape charge?
Got it. Thank you. Anybody else? So yeah, this is essentially the time in which the Supreme Court takes up whether or not we're going to continue to execute individuals for anything less than a homicide. That is essentially the question. Does it violate the Eighth Amendment to essentially kind of punish disproportionately to the crime you committed? So essentially the court is kind of what the court is kind of asked to consider. Is it a violation of the Eighth Amendment to sentence someone to death if they did not also bring about the death of another individual? That's the question. It's not necessarily a better way to phrase it, other than, is it unconstitutional to put someone, or to, as Joshua said, to impose the death penalty on anything less than a homicide? That's what we're asked. Generally speaking, if you guys hadn't read Coker, you get to reconstruct your individual ideas of the world, or of the United States, or of a legal system. in your legal system, assuming that you, Taylor, it's giving lex talionis. Great point. Taylor, what is lex talionis?
It's basically like an eye for an eye, which is kind of how things started off with the CJ system a little bit.
Very much. So the original, if we can go like put in our brains and go all the way back to like intro. I don't know if I had any of you for intro. Actually, that's not true. I think I know I had Adrian and Kevin for intro, I think. But if you go all the way back to those days and remember the original codes that we had, the first kind of written legal codes that we had, the Code of Hammurabi, those were also known to be quite draconian and eye for an eye kind of in mentality. Lex talionis means law of the talon, or like a strict law, which again is usually used to depict things that are an eye for an eye or just kind of draconian, and that's a word I really like. That just means harsh, especially like if it's a old method of being harsh. That is what the court is kind of taking up issue with, how far out of touch. And that's usually really what the court is always asking itself in capital punishment cases. How far out of touch are we on this issue? Because going all the way back, what's the standard for whether or not a question or excuse me, whether or not something violates the Eighth Amendment via cruel and unusual punishment, or is cruel and unusual punishment? They might know what the standard is. They mention it in this case. Gracie, go ahead.
It says a punishment is excessive and unconstitutional if one, it makes no measurement contribution to acceptable goals of punishment, and hence nothing more than purposely imposing pain. And then two, is grossly out of proportionate of the severity of the crime.
Excellent. So that's what the court is deciding in this particular case, is that it is one, immeasurate, meaning disproportionate. It punishes disproportionately. If you did not take a life, we should not be taking a life. And then two, it is again out of proportion. That's the concern. What is the standard for, let's say, like methods of capital punishment? Does anybody know? Or how we punish generally, more broadly? Has anyone ever heard the expression or the standard evolving standards of human decency? Okay, well, when we get into the next case, when we discuss methods of execution, that is generally what capital punishment asks itself, or what people or jurisprudence in capital punishment asks is, what is the evolving standard of human decency? So what do we consider decent in our own concept? So I want you to, again, suspend the ideas for some of you who I know who are already opposed to capital punishment, but assume that in your own little world, you have to impose capital punishment for something. Where would you have drawn the line? So this is an open up for discussion. Again, assuming Coker is not a case, you exist in your own world, you have to impose the death penalty. What kinds of crimes would you authorize the death penalty for?
Rape of a child.
Ellie's a fast one.
Bestiality.
Lorena. All right.
No, I agree with Ellie.
Ellie, okay. Oh, sorry. Who said that one?
If the person has like some form of like mental disability, or like they have record of it, then I would potentially not lean towards it. Also, if it was maybe like someone under the age of 18 to get the death penalty, I may think about it twice.
So those are the limits that you're concerned with, is the offender and whether or not they have essentially kind of a right state of mind and a culpability, but not so much the crime. Ellie has said crimes against animals and crimes against sex, specifically sex crimes against children. Taylor chimed in on the chat and said crimes against vulnerable populations. So in addition to children and animals, what is there another specific that we would add to that vulnerable population? And also, what do we mean by crimes? Do you mean like stealing from? Like if I $5 from what Josh is chiming in on the chat and saying the elderly population, if I take $5 from my Nana's purse, should I get the death penalty? Just so you guys know, also like fraudulent, I can't remember what the word is, but essentially it's fraudulent stealing from the elderly population, it's specifically individuals age 65 and older, is a special category of offense, just so you know. Because the court is very always concerned about whether or not you're taking advantage of old people or young or very young people. So it is an additional crime to fraudulently take money or charge an elderly person in a way that they can't understand. So yeah, we have some parameters. What else?
I would say like mass murders, like school shootings or
Gotcha.
trying to think of another example.
Or
So,
like
like,
other
domestic
terror.
violence.
That's what I was
Terrorists or,
gonna say,
hate
Taylor. Yeah.
crimes.
Joshua, go ahead.
I don't know if someone already said this, but like targeted killings, I would say, against like specific groups of people. Like, I don't know if that was implied when someone said vulnerable populations, but like if you're specifically targeting one certain race or like genocide, stuff like that, that would also be like where you would impose the death penalty, I guess, because you're kind of like wiping out entire population of people, and that's kind of like excessive, extreme excessive.
Yeah, so Taylor's saying like essentially like hate crimes, violent hate crimes.
Yeah, pretty much.
Gotcha. Anybody else want to chime in with how they might impose the death penalty if they didn't have the limits of Coker or our legal system?
One case that I was thinking about personally
Mhm.
was the Gabriel Fernandez case.
All right, the child abuse
And-
case.
Yeah, but I feel like for me personally, like I want to say, yeah, like child abuse that bad, yes. But in the back of my head, I'm also thinking about like, what if someone is wrongly accused, you know?
Mhm.
So it would be like a 80-20 on that for me. But just watching the documentary, honestly, most of the people I've asked, they've had the same thoughts as me. Like they're mad that she didn't get the death penalty for pleading guilty.
Mhm. Which I think that's why I like this particular case, is because it gets at some of those feelings that we kind of instinctually have about the death penalty. Taylor says, Casey fucking Anthony. I have to laugh because when I taught, does anyone remember when we had 3510 and we talked about Casey Anthony? Like anyone have law? Ben was in that class. We had law when we had, there was a semester I taught law and society, and Casey Anthony came up. I swear to God. Like, and it was one particular student's fault because they were really perturbed with the outcome of the case and they presented on the case, so we just kind of kept bringing it up. So yes, a lot of those kind of particular issues. So Michaela's asking, I should know this, but is there a higher burden of proof? No, there is no. It's still beyond a reasonable doubt, but there is two different trials. So what happens, Casey Anthony was sorry, I'm going to answer Casey Anthony first, and then it's bouncing. All right, death penalty, one question at a time. The first one, is there a higher burden of proof? No. You go through the same trial and you assess guilt only. But you have to have what's called a death certified jury, meaning the jury or the jury members before the case started or before the trial started, excuse me, had to essentially say that if they found someone guilty, they would be okay with giving the death penalty. So they had to, in theory, be okay with it, which can tell you a little bit about how jury selection and death penalty cases go. So if a jury is supposed to be a jury of your peers, and we know that roughly 50% of the population vehemently oppose the death penalty, is a jury that consists of 100% of people who don't oppose the death penalty a jury of your peers? No, because it would necessarily need to include people who vehemently oppose the death penalty. But we don't allow that because then we would have to recognize that they're going to definitely vote no. And then we can't have death penalties happen, or we can't carry out an execution. So we have to have what we call death qualified juries. So people who are literally signing up to say they're okay with the process, which again tells you how things are typically going to go once we get to that point. But then we get to after guilt is determined, assuming that a guilty verdict is rendered and it is on murder in the first degree and not on a lower charge, then the jury will hear a series of mitigation evidence and potentially aggravation evidence from the prosecution. So the prosecution will be able to put on potential victim and witness impact statements, in addition to re-litigating some of the facts of the crime. And then the defense will be allowed to put on mitigation evidence that will talk about the defendant and their history. And then the jury will have to decide whether or not, based on hearing all of that evidence, they think death is the only possible outcome here. So that's the death penalty. Not a higher burden, but the prosecutor does have to jump through a few more steps. Casey Anthony. Yeah, you could just watch a YouTube video, short, sweet, and simple. A young woman had a young child. That child ended up going missing. It was like and the mother was not really, missing. The mother was not really, seemed to not really be concerned. There were a lot of social media images of her out partying. A few days later, the child's body turns up not far from the family home with duct tape over her mouth, wrapped in her childhood blanket. Eventually the mother is Ellie's recommending a particular documentary called Where the Truth Lies. Also, Casey Anthony gave a very long interview to HBO like not that long ago, so you could watch that as well. She was eventually tried for the murder of her daughter, and she essentially asserted an affirmative defense, which was like she didn't kill her, but she drowned in the family pool. And then she kind of panicked and didn't know what to do. And the dad, who had a Peacock, not HBO, it's on Peacock. The dad had a long history of sexual abuse, and she said that, she didn't really know what to do in that situation and that she trusted him. And because of this long history of abuse, some of which was sexual abuse between her father, it was like a really manipulative situation, and he told her what to do. No one's really quite sure. If you're not catching on by my confusing statements and the confusing nature of this, no one's really quite sure what happened. We're still not sure. All we know is that she was found not guilty of murder. And everybody feels very strongly about it, just like we feel very strongly about OJ, or we feel very strongly about other instances where we're just like, what? How in the world? One, how does it happen? Terrible prosecution. Two, great defense attorneys. That's how. Every time. Look it up. It's always a combination of the two. It is never just one without the other. So yes, most of those situations, and Gabriel Fernandez was another situation, but his mother and the boyfriend who were engaged in the horrible, horrible assault and abuse of Gabriel Fernandez were found guilty, and the boyfriend, or I don't know if he's a father. No, he was not. He was a boyfriend, was sentenced to death. The mother in that case was able to plead guilty after the trial of the boyfriend and agreed essentially to plead guilty in exchange for the death penalty not being on the table and not being executed. Taylor, go ahead. You have your hand up.
Okay, so Christopher Watts.
Okay.
I feel like maybe since this happened with a big gap of time, those of you who don't know, Christopher Watts killed his two daughters, his wife, who was also pregnant with their third child at the time. I feel like what we did not do is learn from Casey Anthony. And so I'm looking, and it says his sentence was 3 consecutive life sentences. Two things I'm confused with. Why was the death penalty not thought of for this since it was multiple victims? And two, we know that she was pregnant. Why was that not considered a 4th life sentence?
That is a great question. I actually don't know. Because usually when a pregnant person is murdered, you can charge for 2, not only kill, but stuff the small. No. So I'm not familiar with this case necessarily. Or as specifically, where is this case? What state?
Is it North Carolina? I know the woman was alleged to have been having an affair, and maybe her parents, and the boyfriend were in North Carolina. Hold.
He's serving in Wisconsin.
So that's where I was gonna say, so that's where I assume that's where it happened then. And one, I don't know if Wisconsin has the death penalty. I don't know. There are several states that have abolished the death penalty, particularly northern states. So that could be a reason that it was not on the table. Or two, if Ellie is correct, and there was some suggestion that the mother or the victim was having an affair, that if that were proven to be true, and I know everyone's going to riot when I say this, unfortunately, that is a characteristic that the prosecutor will consider, because that might have reduced his culpability from murder in the first degree to homicide or murder in the second degree. Oh, look it up in Colorado. I don't think Colorado has a death penalty.
Yeah, I was
Oh.
in Colorado, and
But I don't know if Colorado has a death penalty. I don't know. Don't think so.
no,
I was
they
gonna say,
abolished the death penalty in 2020.
I was gonna say, I'm pretty sure they did. I don't say, didn't think it was super recently, so I'm glad I was right about that. But they're a pretty progressive state in most regards, so I would have been surprised even if they had. I don't think they gave the death penalty to the Aurora, Colorado shooter. And obviously that was an incident of domestic terrorism, so I'm not entirely certain. That's just generally not a thing the state does. Josh was asking if there is a lover quarrel statute for infidelity. It is not necessarily a statute. However, it's one of those, I hate it. I hate that, especially those of you who, and I talk about it on my first day of class, I am a polyamorous person. I do not believe in, I do not practice monogamy. It's not a thing that I feel is that I need to be tied to an individual for my entire life. So the concept that jealousy of your partner can be used to essentially reduce your culpability in homicide, guys, not like stealing, not punching, not domestic homicide, murder, could be you, like your jealousy at what your partner is doing with someone else that you're not around and you don't know and you have no idea, can be used to mitigate responsibility for their homicide. So I have very strong feelings about that just generally as a person. But it is also true that it's a recognized kind of exception that when someone learns about a partner's infidelity, then it becomes kind of at play in their own murder trial, where if they were doing or engaging in behavior that potentially aggravated the defendant to a point where they could have reacted from that place of anger, and reasonably so, or if a reasonable person, upon hearing that information, as Taylor's pointing out, it's called crime of passion. That's the common term that we recognize. If it's looking up like that, or it's looking like that might be an issue in the case, then the prosecutor might very well want to take the death penalty off the table and be like, look, I'm taking it off the table. I'm going to take murder one off the table. I will give you this for a plea so that we don't have to drag victims through it. Because then that's the other real concern, because we want to make sure that we get justice for the individual who was murdered and had their life taken away. But the reality is we're also going to have to still put forward a trial in which we're going to have to convince 12 people to agree with us. So we need to make sure lawyers we're all about kind of assessing risk and what our likelihood is, which is kind of a weird stats thing. And I didn't really think I'd be doing a lot of that when I was a lawyer. Unfortunately, I did. But it was more on hedging bets, whether you feel like this is going to happen or this is going to happen. And that's sometimes what prosecutors are doing and why they may or may not bring up that information. Gracie, you've had your hand up for a minute. Go ahead, sweetie.
I was looking up if Tennessee still has the death penalty and
Yes, it absolutely does.
It says Governor Lee put a hold on it in 2020 because like the lethal injection protocol wasn't right or whatever. Have they fixed that?
No, not to my knowledge. And that is that's true for a lot of states where lethal injection is. However, do you want to know what we've done instead? So there is a moratorium because of lethal injection and the cocktail that the drug, or there's been a lot of recent discovery about how the kind of drug cocktail that's used, one, we can't get it to be manufactured anymore. And we'll talk some more about this on the next case because it's about methods. You can't get it anymore and people won't sell it to us anymore because they know what we're using it for. And then there's also been more evidence that it's actually not as pain-free as we think it is, especially if you don't do it in a timely fashion. Then there's a lot of evidence that if you are not like right on that time frame, then a lot of actual pain and suffering is caused. So while that litigation and research has still been pending, there have been moratoriums on the death penalty in places that still use lethal injection as the main method. Do you want to know what the South has done in response to the moratoriums?
Tried to reintroduce firing squad?
Correct. Just this year alone, Tennessee, Alabama, Mississippi have reintroduced methods in their state legislatures to make the firing squad, to make hanging, and to make the gas chamber legal. Again, we're going to discuss methods all more next time, so I don't want to get too down in the weeds into this. So that is why we're not super concerned about it, because the legislature is going to try to bring it back in a different way. And also, there's been moratoriums that happen on the death penalty for years, and they'll come back eventually once the issue is kind of resolved. Or what sometimes happens is eventually the state kind of moves. Colorado had done that, I believe. Lots of states who end up eventually abolishing the death penalty will have a very long moratorium that seems to like kind of last for a long time, and then all of a sudden they just kind of abolish it because no one's used it in a long time. So I don't really think there's much to think behind Tennessee's, especially given what the legislature is trying to do. I think the governor is just trying to make sure he doesn't involve himself in any more very expensive lawsuits, because death penalty litigation is extremely expensive. So, but great question. Moving back to the issues. Abdullah, did you have anything?
No, I just wanted to like input like on the previous issues.
Yeah, for sure.
That on going back to the mother and her child, the mother and her child, there was also a story that I saw recently of where a mother left her, I believe it was like 6 or 7 month old baby in like the playpen, and she left the house for 10 days to go on vacation.
Yes. I have read, so at the last internship I worked at the CVRCC, for those of you who had me as a teacher last year, knew I worked there for the entire year as an intern, and one of my regular jobs was to read and input the homicide reports. I wish I could give you a percentage of children-related homicides. Actually, I could. I would say about 90% of child-related homicides have to do with neglect of that variety, just like straight up leaving your child, or usually neglect at the hand of, and it's, I again, don't mean to gender this or anything like that. I'm not trying to, but it's always mother's boyfriend. 90% of the time. Mother's boyfriend either killed child by accident, gross neglect, or mother grossly neglected child. Almost always.
Almost always, and it's sickening because how can you leave a child for 10 days in a playpen and then go on vacation to Puerto Rico?
And I had a client, so I had a client who was charged with child abuse and neglect. It was a felony level, but the prosecutor was very aware that my client had significant mental health issues, and really, really wanted to help. I also really loved this prosecutor. She was a DV and child sex prosecutor after being on violent crimes and stuff. So she had just a very no nonsense, straightforward approach, which I really appreciated because she always kind of knew where she stood. And she recognized my client had a lot of mental health issues. So what happened was my client had been gone from the house for, I think, at least 3 days, and had left her 12-year-old in charge of her 3 younger children, all of which were under the age of 2. And none were potty trained. And the 12-year-old had made several videos on her iPad and had shown them to her grandmother or another trusted adult. I can't remember exactly who the trusted adult was after the situation resolved itself. But that is when they started proceedings to remove and put all of her children into custody. And what is fascinating to me about that experience was that my client did not believe that her 12-year-old intended to testify against her, and therefore, like, she thought she could just like not plea and we could force a trial. She was like, no, because you can't make my daughter. And I was like, no, not only can they can't make your daughter. You're right, and they're not going to. But your daughter definitely already testified already and made videos about how you neglected this, and like those videos are going to be allowed to be in evidence. So even if they don't make your daughter, the videos that she made are going to come in as evidence, and they depict what happened over the course of the days. But she just like would not believe that her child would testify against her, and kind of seemed to be suggesting that there was like a parent-child immunity, like, we talked about with spousal immunity. That does not exist. But I think all this is coming back to and even on the chat, the issues of like, how do you forget or neglect a child, all these coming back to like, we generally, even though we recognize that the death penalty we reserve for death issues, there is like this intrinsic thing in all of us as humans, I think, that respond to situations, especially involving children and child abuse, especially if the child dies or is sexually assaulted, feel very strongly that more strong punishments, or that the death penalty, in fact, may be appropriate. Now, I think it's interesting to point out, and I don't remember if it was Ellie or if it was Josh or who said it, but someone was talking about how that would make them more concerned, or maybe it was even Victoria, someone made concerned about, adding those crimes, and then what happens if they are innocent, and then you have potentially, you have all these other claims. And I think that is essentially why the Supreme Court won't go any further and won't again potentially. So what's the outcome in this case? Let's just pause the discussion there. What does the Supreme Court say to the issue of whether or not it's constitutional to execute someone for a crime other than homicide?
They said it wasn't.
Yeah. Michaela and Josh are both chiming in to say it is not. So they say it is disproportionate given that test that Gracie told us about earlier. It's immeasurate with the crime itself, to it's out of proportion. I don't know why they use two different things to tell you the same thing, but it's essentially saying these things don't match. Punishment doesn't match the crime, and it also just doesn't comport with what we know as the evolving standards of human decency. Now, as humans, we are only at the point where we're punishing with death when it's an eye for an eye. If you took the life of someone else, now the state, if there are aggravating factors and no mitigating factors, can take your life, but only in that circumstance. So we know that that's what the Supreme Court has decided in Coker. What's the state of Georgia's kind of point? And I feel like they kind of have a good point on this one.
That he ruined her life, or like took a lot from her by sexually assaulting her.
Yeah. So, okay, there was actually two really good points I think the state of Georgia had. That is one of them. I want to talk about that one. What's the second one? What's the fact?
Was it that he's a repeat offender?
Yeah, a repeat offender of like a kidnapping. And for all we would have known, this could have or would have easily been another homicide. And he was literally in prison for murder the first time. So the exact reason that we authorize the death penalty, which is that we are afraid of the kinds of crimes that a person will commit in the future if they are allowed to be in society again, is it literally just happened. So like if anyone had good grounds to say like, hey, the whole reason for the death penalty is to prevent what this guy did, and if we don't give him the death penalty, then what is it even for? I think Georgia had a pretty strong logistical argument as far as that concerned. But the second argument, or it was the first one that Ellie brought up, but the second one that we're going to discuss is about the bigger point. Those of you, actually, no, I'm not going to ask that, but just think of anyone in your life. We know that 2 out of 3 women have been sexually assaulted in their lifetimes. How do you think a person, if you know one of those 2 out of 3 women, or people who are femme identifying, how do you think they would feel about the majority's opinion that rape does not have lifelong consequences and therefore should not be punished like homicide?
Even if rape doesn't have long-term consequences, it still has long-term trauma to the victim. Emotional, physical trauma towards the victim. That way, when a woman gets raped, she cannot physically be comfortable with any man near her body because she fears that what happened to her back then will happen to her again, or that she will just be used. That's why women nowadays are more fearful of being comfortable around a man, because they don't want to let their guard down and be used like how they were when they were either raped as a child, raped as a teenager, or now.
And Joshua chimed in while you were talking, Abdullah, to kind of echo that and say, they would be outraged. And, he shares in that outrage without even needing the identifier as a woman. And then Taylor's chiming in to talk about how we know the court's general position on women's bodies. Gracie, go ahead. What do you want to say?
It would also probably make less women want to come forward with their stories and not be more open to share because there's no serious punishment at all. So no reason to tell anybody.
Yeah, so what does this holding really have? What does this holding really say or about our feminist movements in the country? Or let's kind of put this in context of what the Supreme Court has done recently by overruling Roe v. Wade, and now saying, and also saying that people who commit rape and maybe impregnate a person, they're going to be forced to carry that child to term, and their offender it doesn't cause lifelong consequences, though, right?
A 13-year-old just gave birth in Mississippi because she was raped in her front yard at 12 and could not get access.
And a 10-year-old was charged with homicide in Ohio for attempting to procure an abortion after the same thing happened to that 10-year-old. So what is cruel and unusual punishment?
Well, I kind of have like a reverse thing.
Go ahead.
I know it was like last week or so we were talking about how you can get charged for abortions and like homicide and stuff. So in that case, like you were saying, a 10-year-old, say they were to get pregnant and they try to have an abortion, could they get charged for homicide?
Yes, they can. That 10-year-old was the prosecutor, and this was it actually got made national headlines because it was a case in which Meta, aka Facebook, had provided private messages between the 10-year-old and her friend, and they had been discussing what was going to happen. And Meta's position was, hey, well, we didn't know. You just said you wanted the messages. We didn't know that they were going to be used to prosecute a 10-year-old for homicide, for an abortion. And to which everyone's response was like, this is why we don't want you to have control of security settings, because you don't fact check anything before you provide data to people. So yeah, they had used just like a records request to Meta to get the information the prosecutor had, and then had access to the information. And the 10-year-old was charged because they told their friend on a Facebook chat that that's where they were going. And also, again, because this is a homicide, can these individuals be charged as an adult? As somebody reminded me in the chat, because it's a homicide.
They can be tried as an adult.
Yes, they can be tried as an adult. Now, remember, the death penalty does not exist, as we will learn, or actually, there are bounds. The bounds of the death penalty: you cannot execute someone who is mentally ill. You cannot execute someone who was under the age of 18 when their crime was committed. And I think there are a few other stipulations. Individuals who are, ironically, you can't execute an individual who is like terminally ill and dying of cancer. You can't do that. So that seems like we want you to be physically very well before we kill you, physically and mentally well before we kill you. So if you're in any state of distress, you cannot be executed, but that's kind of the limitation, or under the age of 18. Before that, I'm so sorry, Gracie, what were the point you
What
had?
about
Go ahead, Ellie. Go ahead.
Well, you talk about like they want you to be like super healthy and stuff, and like you can't execute people that have like mental handicaps, but not necessarily mental illnesses. Like you have to be to a certain point. So what about people who are just like sick in the head, but not necessarily like sick, but like have like a chronic anxiety disorder or something? Like,
great question. If you experience psychosis leading up to your execution, no, because you are no longer capable of understanding what's going on. So they will have to medicate you to a place of mental wellness until you are capable or competent, and then they can execute you.
Mental wellness, like, wow, interesting.
But going back to the kind of disproportionate issue, or the issue of potentially trying, or the issue of not seeing rape as a lifelong consequence. To me, in combination with the other law that Supreme Court has generally put forward with how we police, how we protect, how we don't protect, how we tell people generally what they can and can't do with their bodies, this one is one to me that doesn't really make sense, especially when we start talking, as you guys have, about crimes against children, or crimes that generally seem to be indicative, or crimes that are, we know that there are certain offenses where individuals are more likely to offend than others. Interestingly enough, though, homicide isn't one of them. Homicide is not one of the crimes that there is a high level of recidivism for, unless you're Mr. Coker. He just can't quit, or you're Ted Bundy. Like those few people, sure, but other people generally it's not high recidivism. So if that is the case, then what? But we know other offenses like rape, because again, the compulsion to engage in that kind of offense is very different, or that motivating is very different than what motivates individuals who may be involved or may be guilty of a homicide. So since we know that individuals who are engaged in a homicide are much more likely to be, kind of affected emotionally by what's going on, they're much more likely to be involved in a situation that is heated versus an individual who engages in sexual assault. That's pretty much always planned and thought out and intentional. And if that's the same thing as intent, or if that kind of intent is still present, which is why we punish murder in the first degree, then why isn't something with the same level of intent to harm, to which the Supreme Court's best response is because there's no lifelong consequences?
They think there's no lifelong consequences because they are not put in the victim's shoes.
This is where Abdullah is on my screen, sorry.
Because the Supreme Court justifies there's no long-term consequences because they are not putting themselves in the victim's shoes because they have not experienced what has been done to the victim. Lifelong
Absolutely.
consequences for the victim, meaning a trauma, emotional trauma, distancing themselves from others. I know females that I've been friends with since high school that have experienced this, and they have distanced themselves from everybody.
Yeah.
They have distanced themselves from family, friends, from significant others. They have no social life now because they are afraid to put themselves out into the world and to make themselves known because of what might happen again.
Absolutely. And as Ben rightly points out, there are 9 men on the court at the time in which Coker is decided. So not yet has there been a single woman appointed to the court. How much do we think, and to quote, actually, Justice Powell, who wrote the opinion, there was no sign in this case that, quote, the rape offense was committed with excessive brutality or that the victim sustained serious or lasting injury. So
lasting physical injury, not emotional injury.
Absolutely. So what do we think about the fact that 9 men wrote this opinion? And we haven't revisited this, but we have revisited the right to an abortion.
The fact that 9 men came to a consensus that, yes, this is what we're going to go do, this is what we're going to go through, is beyond me, because why would you go through that? If I was on the Supreme Court, I would say, what if that was my mother? What if that was my sister? Then I would make a logical, concise agreement with the rest of my colleagues saying, no, this is not how we're going to do things. We do not need to agree to this.
So I'm going to call out everyone who identifies as male in this classroom, then to come up with that is an argument that is presented to you. How do you respond? Abdullah just told us how he would respond. No, because I'm checking with the people in my life who can speak to this issue, and they feel differently. How do you respond? I'm not going to allow women to talk in this class because that's not what we do in the Supreme Court. Please know that I'm being very facetious. You are obviously allowed to talk, but I'm very serious. I want to open up to the floor to the men in the room. How do you defend that position? This is your demographic, John. Go ahead.
Hey, my bad. I had stepped away. What is it that we're responding to?
So it was 9 men who made the opinion of the court, which is that rape there's no evidence in the record that rape rape in this particular instance had was inflicted with any kind of excessive force, or that there was any lifelong and sustained and serious injury from the incident. And that therefore it is disproportionate to punish him with a death sentence.
So you're like asking how we would respond, like how do we feel about them saying that?
How do you feel as a man about the fact that 9 other men made that decision?
I mean, that just kind of seems like a fucking escape. Like they're just trying to deflect and not really say the truth. I mean, me personally, I feel like if someone I knew, like a female family member or someone who identifies as female who's related to me, or even a friend, was raped, I think deep down, like, I don't want that person to get the death penalty. That's the quick way out. Like, I would almost rather them go
Really?
to jail for life. Yeah.
Yeah, because John,
And
what's
if you get
true
the death
about
penalty,
people?
it's
Yeah, what's true about
done.
people who go to prison on sexual assault charges?
I mean, they get it back.
How long did Jeffrey Dahmer live?
He was the one that had his head beat in by the with the metal plate, wasn't it? It was only like a few more years, right?
2 years.
He
It
could
was
have
two
punched
years
those
in
buttons and
2 years into his many life sentences. And remember, Jeffrey Dahmer, although we're of course he's very famous for the dismembering and keeping of his bodies, but the assault or the actual nature of the crimes was that he would routinely seek out and target young boys of color to assault and physically and sexually assault before eventually killing and dismembering them. So when we're talking about Dahmer in comparison to other serial killers who faced significant amount of violence in prison. So for them, a lot of those individuals end up in protective custody. The individuals that you guys have talked about, potentially wanting to see on death row, individuals who've committed child assault, a lot of times they are all in protective custody. So now knowing that, how do you all feel about that offense? That instead they're serving their prison sentence in protective custody instead of on death row?
I think that the justice system is screwed. We are truly screwed as a generation, as a community, that the justice system has failed us.
Thank you, Abdullah, for that comment. Josh, you've had your hand up for a minute. Go ahead.
Why are we protecting people who obviously don't have a regard on how to like act properly in society? Why are we continuing to like give them special parameters, trying to keep them safe when they couldn't even take like the proper measures of themselves to try to keep other people safe? Like that's my understanding. Like I feel as though if you do the crime, especially at that level of crime, then you should be with the people who have committed the crimes equally as bad, because I'm not saying that like raping somebody and killing somebody is the same thing, but those are both egregiously pretty big crimes that would leave a very severe emotional impact on somebody, whether it be the person, the victim, or the victim's families. Like it affects everybody.
Absolutely. Such a good point, Josh.
Josh.
What also I
Not
find, go ahead, Abdullah.
not only that especially if they're put in protective custody and not on death row, then that means that the justice system wants to see them out into the world, because the justice system, every time someone is put either in on protective custody or in jail, consistently in jail, like a repeat offender, I want to say that they earn like monetary gain from it. Like for each like person that occupies a certain penitentiary or a certain jail, like they earn like funds from the government to like either expand or reduce that jail.
If I'm
So
not
I feel
mistaken,
that,
you're correct to some extent. Like obviously budgets are always depending on whatever, but yes, the more
yeah,
bodies there are
obviously,
in custody, the more they can request for funding. Yes.
and also to add to that, if they're put into protective custody and not in a gen pool penitentiary or jail, then that means they are put into a gen pool of other criminals that don't take kindly to rape. Because I know, like, I've watched Scared Straight, I've watched like the prison systems documentaries, and I know how easily criminals can pull your file, can pull other criminals' files and see what they've done and how and why are they in prison. And once they find out that it's either rape or sexual assault or child molestation, they will take measures into their own hands and make sure that you stay in jail rotting, not alive, but dead.
And there's a very famous saying, particularly about this issue, that Abdullah is hinting at, is that it's essentially it's honor among thieves. So like
Yes.
you can do some bad stuff in this life, but there is a line that most people, including people in prison, will draw. And so they may be gangbangers and they may be slinging drugs and they may be shooting each other, but they are not having it for individuals who intentionally target children. Josh was chiming in saying, we're basically saying it's okay to get away with doing that to minors or children and rewarding them for bad behavior. And what is really the message that we're sending when, and to me, where it doesn't make sense and where I can't kind of legally even rectify this for you guys is for me, the reason that or logic or the reason that the death penalty is supported is that it's intentional, right? Like the reason this murder was committed with intent, with malice, some level of torture is usually required. Some aggravating factor is usually required to find some person to find that death is appropriate in the case, to find those aggravating factors. And usually you're also presented with mitigation evidence. And a lot of times in death cases, a lot of times you're presented with a mountain of mitigation evidence about a person's sexual abuse as a child or physical abuse as a child, also neglect as a child, or any other potential adverse childhood experiences or traumas that may have happened, and you're allowed to consider that. In a rape case, it's just a question of whether or not we believe consent was provided. Even if we know, like, rape in the first degree is the same level, intent is required. You also have to demonstrate a showing of force. And I can definitely attest to, as having been in courtrooms in some homicides versus some rape cases, some of those are much worse than others. Some homicides are what we would consider quick and easy versus, not every there's not a sexual assault that is a quick and easy sexual assault. That's not a thing. So to me, that's how I can't legally make it make sense, is because if we're using that standard for death penalty to say that's why it's okay to provide death in this situation, because the individual intended it. They sought this person out, they intended to harm them, and then they did so brutally. Are those three things not also true about rape? And even more so, sexual assault of a child?
Imagine the long-term trauma that child is going to be going through throughout the years. Trauma as a newborn will stick with you because
absolutely
once you're a child, you retain memory of everything that happens. You retain every single detail from either happy memories, sad memories, or traumatic memories.
Absolutely.
It stays with you.
And if you guys want to, I highly recommend the book, The Body Keeps the Score on Trauma. It's just about how not only do we keep all of that mentally and emotionally, and we carry that with us, our bodies can also store physical trauma in themselves as well, where that can be a physical response to it, so an injury itself, or it could literally be how our body processes the emotions and the mental processes that we're going through. They also show up physiologically in terms of especially in terms of psychosomatic, symptoms of anxiety that are psychosomatic, like increased heart rate or elevated breath or breath intake or something like that. So that happens pretty constantly. So we can see those physical effects continue to happen to someone even long after. So we can see that for a long time as well. So yeah, Supreme Court says, though, it's not enough. May I ask general thoughts on the dissenting? Yes, Ben, go ahead. What are our general so the thoughts, what particular point in the dissent? Ben says, they mentioned that the victims of rape might be more likely to report the crime if death penalty was allowed. So that is something the dissent says that is a reason that they disagree. And I think the kind of intuitive kind of counter to that, or not counter, but the kind of intuitive next step, or is like, and if the death penalty isn't imposed for rape, then we are less likely to report. We don't think it's going to be taken seriously, which is something someone said earlier. So what do we think of that, especially now that we know the likelihood of being reported for sexual assault is like extremely low, despite the fact that we know at least 2 out of 3 women will experience sexual assault in their lifetime? Go ahead, Ellie.
I just have a thought.
Go ahead.
And I don't know how it's going to be taken, but it just feels really ironic to me that only the men spoke up about like what it feels to be a victim of sexual assault like long term. Like we've moved past that conversation, and I don't know if like maybe the women just didn't have anything to say, or like we just didn't. But I was just sitting on that.
Go. And also, like,
I mean,
do you want to talk about it?
I bet I feel like I better not. I just felt like we had to point out that irony in the fact that we're talking about how only men had this opinion. And then
well, I
only
also asked them. I specifically said,
yeah,
how
absolutely.
would you defend it?
Yeah. I just felt like it was like something that needed to be acknowledged.
But I also like, though, in and keeping with keeping things that we want to acknowledge, that every single one of you who identify as male or identified yourselves as male in that conversation all said, I'm going to ask the people in my life that it affects. You didn't say, I'm going to ask myself. I'm going to look deeply inside myself and see what I would determine from that. You all said, I'm going to ask someone who I think it's going to affect and see what they think the answer would be. Why don't we think, back to Ben's general comments about the dissent, though. Dissent says that we want to encourage people to report. So why not use this? Do you think more people would report if they knew that the death penalty was on the table for sexual assault?
No, because a lot of women, at least in my police department, who report on their abusers, a lot of women are likely to not prosecute. They just want something reported. So there's paper, but then whether it's because they're still intertwined in a relationship or they have children together or they share finances, a lot of women don't prosecute. And so I think if they knew the stakes were so high with death, I think it would go even lower.
Interesting. Anybody else?
I agree with Ellie. Honestly, it would be ideal for people to report it more, but I don't think they would. I think it's also just that kind of, in a way, the embarrassment for a woman, especially if they've taken like some time to actually like own up to it or accept it. I also feel like the time and commitment that goes into it, some women just don't have that tough like personality or ability
It's
to
hard.
really able to go out there.
Because it is super hard to navigate the criminal legal system, especially as a victim in any case, but let alone as a sexual assault, where literally everything comes down to a lot of times your word versus someone else's word. There's not a charge where that is better personified than in sexual assault cases. And something else Lorena said made me think of a point. But Taylor, you have your hand raised for a minute, so go ahead, sweetie.
I have 2 points to this, I guess. One of them being, even if they're more likely to get a death sentence, we're still going to get the victim blaming. What were we wearing? What time was it? Like, did we pursue them first? Like, that is never going to go away, ever. And then my second one is, if we do impose the death penalty for this, imagine all the priests and the uncles and the dads and the brothers who are going to be the target of this, because that's who it's going to be aimed towards. And nobody's going to want to do that, especially when we can't even have separation of church and state. Imagine all these religious figures coming in here and being put up in court for this.
Such a great point, especially because your first point reminded me of what I wanted to say about, I think it was Ellie's or Josh's, but to the point that this would, to Ben's ultimate question of would this increase, I think it would actually decrease as well, Ellie, because of the two-phase trial and the thing that Taylor was talking about. Because now, remember, in death cases, we have 2 phases of trial. First, you assess guilt and innocence. That's just, do we agree? Remember, the second phase of trial becomes what kind of punishment is appropriate. And if you thought we were slut-shaming before when we were just talking about guilt and innocence, now we get to talk about whether death is appropriate. So if all of those factors of what was she wearing and did she initiate the conversation were relevant to guilt, don't you think they're relevant to whether or not they think they deserve death? Oh, absolutely. You not think we're going to get into way more? And also, I think it actually opens up to more victim blaming and shaming happening, because in mitigation and in the aggravation part, then you have to prove that it was aggravated. So now we're going to have essentially like people to talk about whether or not this injury is long standing enough, and is that long enough to be punished with death versus like, is your rape that was brutal, awful, and torture not serious physical injury enough? So your doctors are going to have to testify about that. So I think we're going to have all field probing questions that are going to make victims feel awful about that. I think we might also face a situation, and I think Ellie is very unfortunately right. Even in my own personal experience with people who have been sexually assaulted, as knowing them as friends, or even knowing some of the students that I have known who've come forward and told me why they didn't want to pursue, and even my own experience not wanting to pursue charges, are all related to the fact that I did not want to do it. I did not want to move forward with prosecution, or like the person who was assaulted did not want to go forward and did not want that person, and I can't even believe that I'm saying this because I hate the person, but I did not want that person punished within the confines of the law. And for me, that actually had to do more with the fact that we do have a lifelong punishment for sex offenders. What is that? The registry. Yeah, Ellie was saying it.
Sorry, the
That was it.
registry.
Yeah, I saw you mouth it. The registry. So we do have a lifelong punishment for that. And Vincent, thank you all for chiming in on his particular question. I think that was a great question, and I do think that. And I am so sorry. What was the last thing I just said? Ellie, registration. So there is a lifelong method of punishment for sex offenders and for people who are guilty of this offense, and they are going to be monitored for the rest of their life. And I think that's the best that we're probably going to get. And even then, even knowing that's a punishment, that deters enough people from continuing forward prosecution, because they don't want that person to be monitored for the rest of their life. I mean, if we have people who are saying, no, I don't want to prosecute because I don't want someone to have to be monitored for the rest of their life for something they did to me for this brief period of time, then who's going to come forward if they know that that person might be executed? All right, great class discussion. I'm going to end it there today. We're going to pick up on Wednesday, again, virtual because it's Wednesday, with Glossip v. Gross, and we will talk about methods of execution on Wednesday. So please come back for then, but otherwise you are all free to go today. Thank you so much. I hope you have a great day. Stay safe in the weather. Bye, guys.